Thank you. Please be seated. All right, we're on the record. State of Idaho versus Colby Ried Heaton. Two cases, CR 1024-9705 and 1022-18-3067. Lou Harris is here on behalf of the state. Mr. Heaton is here along with his attorney, Jason Gustavus. So I look at the file, it appears to me that we need to work through a change of plea and then a sentencing. Is that the plan, Mr. Gustavus?
Yes, Your Honor.
All right, Mr. Heaton, there was a plea agreement that was filed in this case July 29. I'm going to just run through the highlights of that plea agreement, just to make sure this is what you agreed to. In case CR 1024-9705, you agree to plead guilty to count 5, battery, domestic violence with traumatic injury, count 7, possession of a controlled substance, count 8, evidence destruction, alteration, or concealment. The state agrees to dismiss counts 1, 2, 3, 4, 6, and 9. You agree that if you violate the terms of the plea agreement, the state can reinstate those dismissed charges. You agree to pay full reasonable restitution on all the charged and uncharged crimes. There will be a joint recommendation for a 5-year determinate and a 5-year indeterminate prison sentence to be imposed, and that is a binding agreement on the court. It's also an agreement that the sentence in today's case will run concurrent with each other. It will also run concurrent with case CR 2012-12074 and CR 22-18-3067. You will agree to admit probation violations in case CR 22-18-3067. And you would have that probation revoked with the sentence being imposed. You would be given credit for time served. Parties are free to argue any other terms of the agreement, and as indicated, the intention is for this court to be bound by this plea agreement under Idaho Criminal Rule 11F1B. Mr. Heaton, is this the agreement you reached with the state of Idaho?
Yes, sir.
Mr. Gustavus, is this the agreement you helped him negotiate on his behalf?
Yes, Your Honor.
Mr. Harris, is this the agreement the state reached with Mr. Heaton?
It is, Your Honor.
All right. Mr. Heaton, I have a series of questions of you before I take your guilty plea. I have questions of Mr. Gustavus before then. Mr. Gustavus, do you believe you had sufficient opportunity to fully investigate these cases and these charges on behalf of Mr. Heaton?
Yes, Your Honor.
Did you have an opportunity to review all the state's evidence that it likely would present if the matter went to trial, and to discuss all of that evidence with Mr. Heaton?
Yes, Your Honor.
Did you also have an opportunity to discuss with Mr. Heaton if he had any evidence in his possession or witnesses that he could call in defense of these charges?
We have discussed and investigated, Your Honor.
Did you discuss with Mr. Heaton whether he had any defenses to the charges he'll plead guilty to today?
We have discussed those.
Knowing what you know about Mr. Heaton, do you believe he is competent enough to understand the charges that he'll plead guilty to and the consequences of pleading guilty?
Yes, I do.
All things being considered, do you consent to Mr. Heaton pleading guilty pursuant to the terms of this written plea agreement?
Yes, Your Honor, I do. And to clarify one thing, he has done compliance with the plea agreement by, we have filed a written acknowledgement of probation violations and filed those in that Fremont County case.
All right, thank you. I appreciate that. All right, Mr. Heaton, I just need to remind you of some things. At this stage of the process, you still have all of your constitutional rights in place. What that means is you have the right to have this matter go to a jury trial. You have the right to confront your accusers. You have the right to present your own defenses. And you have the right against self-incrimination, which is your right to remain silent. Do you understand you still have those constitutional rights in place?
Yes, sir.
But do you also understand that if you're going to change your plea today, you will be waiving those constitutional rights?
Yes.
Okay. First one I want to talk to you about is that right against self-incrimination. What that means is nobody can order or require you to testify or to present any evidence at all if the matter went to a jury that the judge or jury could use to find you guilty of these charges. But if we move forward, I will place you under oath. I will eventually ask you what you did that makes you guilty of these charges. And by answering my questions, you will waive your right against self-incrimination because I will use your own statements to find you guilty of these charges you're going to plead to today. Do you understand that?
Yes, sir.
Knowing all that, do you still want to proceed?
Yes, sir.
All right, then if you would, please stand and raise your right hand and my clerk will place you under oath.
Do you solemnly swear that the testimony you're about to give in this pending cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated. Mr. Gustavus, you'll grab that mic and get a little closer to it, make sure we get an accurate record. Thank you. All right, could you please state your full name?
Colby Heaton,
All right, Mr. Heaton, how old are you?
55.
How far have you gone in school?
I have a HSE.
Okay. Are you having any difficulty understanding me today?
No.
Do you read, write, speak, and understand the English language?
Yes.
Are you feeling well today?
Yes.
Are you under the influence of alcohol, drugs, or other controlled substances today?
No.
Do you have any addiction to alcohol, drugs, or controlled substances?
No.
Are you on probation or parole?
Yes.
Do you understand pleading guilty could have an impact on that probation or parole?
Yes, sir.
Okay. I need to advise you, Mr. Heaton, if for some reason you are not a U.S. citizen, pleading guilty could have an impact on your immigration status. Do you understand that?
Yes.
Do you remember the charges that you're going to plead guilty to today?
Domestic battery, possession of a controlled substance, and evidence destruction.
Okay. And do you remember the possible maximum penalties for the domestic battery charge?
10 years.
That's correct. And for the possession of a controlled substance, the possible maximum?
7.
Correct. And the evidence destruction?
5.
All right. Do you feel you've had sufficient time to fully discuss this case with Mr. Gustavus?
Yes.
Did you have an opportunity to review the state's evidence that it would present if the matter went to a trial?
Yeah.
Did you also have an opportunity to discuss all of that with Mr. Gustavus and discuss with him whether you knew of witnesses that could be called in defense of these charges?
Yes.
Did you ask Mr. Gustavus to do anything that he refused or failed to do?
No.
Do you feel like you had full opportunity to ask all questions of Mr. Gustavus and that he had full opportunity to answer all your questions?
Yeah.
Are you fully satisfied with his representation?
Yeah.
Did anybody try and coerce you to get you to plead guilty today?
No.
Did anybody threaten you to get you to plead guilty today?
No.
Did anybody promise you anything other than what's in the plea agreement to get you to plead guilty today?
No, sir.
Did anybody try and coerce you to get you to plead guilty?
No.
Are you pleading guilty freely and voluntarily?
Yes.
Normally, Mr. Heaton, we would order a pre-sentence investigation report. It's my understanding we're going to proceed directly to sentencing today. So you'll be waiving your right to get an updated pre-sentence report. Is that correct?
Yes, sir.
Okay. All right. Before I actually take the plea, just as a reminder, by pleading guilty today, you're going to waive your right to have the matters heard by a jury. You're going to waive your right to confront your accusers. You will waive your right to present your own defenses. You understand you're waiving those rights today.
Yes, sir.
Because you'll be pleading to felonies, you will for a time lose some constitutional rights, and they include your right to vote, your right to hold public office, your right to serve on a jury, and your right to possess firearms. Do you understand you're losing those constitutional rights today?
Yes, sir.
I need to advise you, if for some reason you're in possession of a firearm after today, you could be subject to additional federal and state prosecution. Do you understand that?
Yes, sir.
Knowing all of those things, Mr. Heaton, is it still your intention to plead guilty pursuant to the plea agreement?
Yes, sir.
Do you need to ask Mr. Gustavus anything before I ask you to enter a plea?
No, sir.
Okay. All right, then with respect to count 5, battery, domestic violence with traumatic injury, Mr. Heaton, how do you plead?
Guilty, Your Honor.
What did you do that makes you guilty of that charge?
Struck Miss Turner.
Okay, let me ask some more questions, okay? Did this happen on or about or between October 3rd, 2024 and October 5, 2024? Is that
Yes.
about right?
Yes, sir.
Did this all happen in Bonneville County, Idaho?
Yes, sir.
And when you struck her, did you inflict traumatic injury on her person by causing black eyes, contusion on the forehead, bruising behind the ears?
I believe so. I didn't see it, yes.
All right. Any reason to think that you didn't cause that when you struck this individual?
No, sir.
All right. Mr. Harris, is that sufficient factual allocation?
It is, Your Honor.
Mr. Gustavus, you agree?
Yes.
Okay. All right, regarding count 7, possession of a controlled substance, Mr. Heaton, how do you plead?
Guilty, Your Honor.
What did you do that makes you guilty of that charge?
Possessed a controlled substance.
Okay, let me ask some more questions. Did this happen on or about October 7, 2024?
Yes, I believe it did.
Did it happen in Bonneville County, Idaho?
Yes, sir.
Was that controlled substance methamphetamine?
Yes, sir.
And you knew it was methamphetamine when it was in your possession?
Yes, sir.
And did you also know that methamphetamine was a controlled substance in Idaho at the time?
Yes, sir.
Okay. Mr. Harris, is that sufficient facts?
Yes, it is, Your Honor.
Mr. Gustavus?
Yes, Your Honor.
Count 8, evidence, destruction, alteration, or concealment. Mr. Heaton, how do you plead?
Guilty, Your Honor.
What did you do that makes you guilty of that charge?
I ate a controlled substance.
Okay? Did this also happen in Bonneville County, Idaho?
Yes, sir.
Did it also happen on or about October 7, 2024?
Yes, sir.
And when you ate that controlled substance, were you doing it to try and prevent it from being discovered or produced by some law enforcement agency?
No, sir.
Well, why did you eat it?
To kill myself.
Okay? Did you also at the time, did you know law enforcement was after you?
Yes.
Okay. Mr. Harris? Now, let me ask this. Let me ask this before you go, Mr. Harris. Mr. Heaton, would you agree that by you eating this controlled substance, law enforcement would not be able to discover it after you ate it? Would you agree with that?
Yes, sir.
All right. Would you also agree that had they discovered that, they possibly could have charged you with an additional crime of possession? If they had found it before you ate it?
Yes, sir.
All right. With that, Mr. Harris, you satisfied?
Yes, Your Honor.
Mr. Gustavus, you agree?
Yes, I would.
All right, I also agree. Do you find that Mr. Heaton understands the charges and the consequences of pleading guilty to those charges? Also finds he understands and consents to the plea agreement he himself signed July 21, 2025. I also find there's a factual basis for the guilty pleas of counts 5, 7, and 8, and that Mr. Heaton knowingly, intelligently, and voluntarily gave that factual basis. We'll enter that as part of the record. With respect to sentencing, Mr. Heaton, you always have a right to have this court prepare a pre-sentence investigation report. My understanding, based on the plea agreement, and based on the fact that we had a previous hearing where we released the pre-sentence investigation report from a previous case, that you're going to be waiving your right to have an updated PSI. Is that correct?
Yes, sir.
Have you had an opportunity to discuss that with Mr. Gustavus?
Yes, sir.
Mr. Gustavus, you agree that you fully discussed Mr. Heaton's right to have an updated PSI, and you concur and agree with the waiver of that, and just to proceed with the PSI prepared in CR 22-18-3067?
Yes, Your Honor, and I have received and reviewed that plea, that PSI.
All right. Mr. Harris, have you also had an opportunity to review that PSI?
Yes, Your Honor.
You also prepared to proceed with sentencing today?
I am.
All right. Mr. Heaton, did you get a chance to review the PSI from that prior case?
A long time ago.
Okay. Mr. Gustavus, any concern with proceeding forward or feel the need to give Mr. Heaton an opportunity to review it again?
No, Your Honor, we've been working together for close to the past year. I'm very familiar with Colby, and I've reviewed this, and he also didn't have any objections to it when it was originally filed, so we're prepared to proceed.
All right, fair enough. So no objection to me relying on that report?
No objection.
Okay. All right. With that, Mr. Harris, do you have a victim impact statement today? State.
Thank you, Your Honor. Colby is 55 years old. He is a single man. He spent a long time living and caring for his mother and his sisters. He has had an unstable youth over time. He had a period of time where, as a juvenile, he was spent time at St. Anthony with the Department of Juvenile Corrections, and upon release, struggled against the reins and was placed on probation, did a retained jurisdiction, and went to prison at an early age, and spent a few years in prison at a very early age. So, quite frankly, he was primed at an early age to that incarceration was a certain particular way of life for him. Over time, he has had periods of where he's been out in the community. He's done very well for a period of time. One of the statements that was in the pre-sentence report from the 2018 case was that he does well while under a very strict level of supervision, and when that level of supervision is relaxed, he starts to struggle. He's had some mental health issues over time. He struggled with a little bit of anxiety, but depression has been more problematic for him over time. He has had levels of treatment for that. They tried to get him into mental health court back in 2018. However, for whatever reason, he was not accepted, and so he was placed on probation after that. So he's had some good times and some bad times. Substances has been a problem for him, and quite frankly, substances were a problem in this case. There was a contested preliminary hearing. The victim was able to testify and tell what happened at that hearing. What we did find out was that for a period of 4 or 5 days, there was heavy substance use by both the victim and Mr. Heaton in the house, which led to the situation that we have now. And when she left, and then he later was encountered law enforcement, was taken into custody. So, and he's been in custody now since October 7th of last year. And this agreement was a mediated agreement where Judge Dunn came up and the victim had a full opportunity to be involved in the decision and to make her goals and her needs met. And so, frankly, this is a mediated agreement that is intended to be binding upon the court because a lot of work went into this and gets everybody's needs taken care of. So with that, for the felony domestic case, we're asking that the court issue a fixed imposed sentence of 5 years with 5 years indeterminate. And on the felony possession, 5 years fixed with 2 years indeterminate. And for the evidence destruction, 5 years fixed with 0 indeterminate to run concurrent with each other, concurrent with the 2012 case and the Fremont 2018 case. Regarding the motion for restitution, I did receive that this morning. I haven't, as of right now, I have an objection. I haven't been able to review that with Mr. Heaton, but also my understanding of the document I was provided is that's an estimate from November of 2024. They should have an invoice by now, which would be a more realistic thing. So at this point, I'll lodge an objection and we could set a hearing for, I don't know, 3 weeks or so.
All right, and that would be my intention. Anytime there's an objection to the restitution, I set it for hearing. And we let it either resolve or maybe the state gets additional information and cleans it up. So we'll take care of that at the end of the day. Thank you.
And I will submit.
Thank you. Mr. Harris, comment, recommendation from the state.
Yes, Your Honor. I'll run through this the way I typically do. Otherwise, if I start on a restitution issue, I'll go from bad to worse probably. Relative to the record, should I just stick?
It's easier if you sit in this courtroom.
Okay.
Thank you.
That's what I recall. So we're using the PSI from the 2019 was when it was adjudicated, but it was a 2018 incident. And as highlighted by counsel, Mr. Heaton has been, the wording of the PSI is actively involved in the criminal justice system since 1986. That's, it's over 30 years. That's someone getting to a life sentence a bit at a time, even as far back as his juvenile experiences. Mr. Heaton would start out with some sort of a supervision, go off the rails, and end up incarcerated, or I guess detention would be what we would call it at that time. But it was the same idea. He would start supervised, go off the rails, and end up supervised and in custody. And that unfortunately has been a pattern. And I want to focus on that because we find that after being released from his most recent juvenile detention, Mr. Heaton absconded again and returned to custody in '97, was incarcerated till 2000, sentenced to probation in 2001, and that was for a reckless driving, careless driving, domestic battery. By 2002, he had been charged with 3 counts of forgery, and by October of 2002 was in prison again. Remained there until October of 2005 when he got a final discharge from IDAHO. And by the following January of '06, he was already looking at new charges. Ended up with 4 years of probation, but by October 2006, later that year, because of probation violations, again it was revoked and he was sentenced to prison. And the new charge was one that included eluding, fleeing, and driving a vehicle without owner's consent. So it literally went, as I've mentioned, in a pattern that has continued. The 2018 charge that was the reason for the PSI that we're working from today was, once again, he was incarcerated till 2011 on parole, and once on parole, he ended up with the 2018 eluding because of a relapse. And the PSI investigator at the time said, and I'll quote that, it will be a very long time before he will be amenable to community supervision. That was after the 2018 incident. In between that, there was a 2012 incident that was an aggravated battery, aggravated assault with an enhancement for the use of a deadly weapon that included that particular incident is like deja vu to this present case, where there were allegations which, relative to the outcome, it's no longer allegations, but where the victim there stated that she had been attacked with a hammer, hit with a heavy ashtray, a glass ashtray, and at one point told, "We're not going to live through this," prior to the defendant driving the vehicle towards the river, and she was able to escape that by jumping out of a moving car. Prior to that, there was of course heavy drug use, and Mr. Heaton became paranoid delusional, would not let the victim leave the home during any of that incident. As I said, it reads like deja vu to the present case. And even at the end of that, there was support for a specialty court from the parole officer, Jonathan Craney, at the time, but he did leave that with this particular statement. He said that if the defendant is not accepted into a specialty court, Mr. Heaton should be returned to prison. At each opportunity, at each level of supervision, it seems that always ends up being the only place that he's able to be safe, society's able to be safe, and he's able to be safe from his own worst instincts. I'll leave it at that. As I reviewed the PSI, I noted that Mr. Heaton's physical health was generally good. He has some issues, but with medication, he seems to do well with those issues. Mental health is a different situation. There was a suicide attempt in November of 2018, which was part of the 2018 incident that the eluding and all of that included that culminated in his 2019 prison sentence. The evaluator suggests that Mr. Heaton may have been underreporting as he appeared to minimize mental health concerns. I wondered what that meant at the time, and to be honest, I could only come up with one way of discerning what that indicated, at least to me. And that was, although Mr. Heaton's able to be stable for long periods of time, he expressed himself that prior to the 2018 incident, that he was stable for about 6.5 years, a very long time. And during that time, he was a reliable employee. He was able to pay his own bills, take care of himself, and he even at a certain point became a supervisor or manager at his employment. He did well for a significant period of time. The problem is his anxiety, his fears, whatever he's dealing with, he chose to recidivate. That is to go back to the old standby, which is drugs. He went back to meth and other drugs, and when he goes back to those, the results are the same. They're always the same. The results of drug use for Mr. Heaton has been victim crimes and violent victim crimes, and no one is accepted from those victim crimes. I noted that as far back, I went back to one of his earliest crimes, which was a forgery case. The victim in that case, his own mother. And although the victims may have changed over the years, they often end up being those closest to him, whoever's closest to him at the time. And once he relapses, falls off the wagon, they're in danger. And the danger seems to only ramp up over time. It gets worse and worse and worse. The PSI, and again back for the 2018, again sentenced in 2019 case, the PSI recommended, and I'll read that recommendation. Without intensive supervision / treatment, I do not believe Mr. Heaton should be returned to community supervision. Instead, I recommend the defendant remain incarcerated for his personal safety and the safety of the community. And again, nothing's changed. That is to say, once he begins taking those substances in, the outcome is the same, and I believe that, again, the recommendation should be the same. that Mr. Heaton, for his own safety, especially when we include someone that has in multiple occasions undertaken to elude law enforcement, that not only for the safety of society, but for his own. Because any of those types of instances could easily have ended with Mr. Heaton's death, as well as, of course, the death of citizens that had gotten in his path. So I believe this is the most apt recommendation, even as far back as, again, a 2019 case. And I would note that, well, I won't go there just yet. My thought is that in looking at all of that line of cases, and it's a lot, 32 felony convictions, 33 misdemeanors, it's a lot. But in looking at those, I see that Mr. Heaton is, he's as he presents today. That is to say, probably a nice guy, quiet, soft-spoken, and a reliable employee for over 6.5 years. But each time he relapses, if everyone has a Jekyll and a Hyde, without any type of, without fail, once he relapses, the Hyde side comes out. And when he does, people are in danger. I do believe that Mr. Heaton needs treatment. I believe that he deserves to have that treatment, and possibly and of course an opportunity to return to society. But for now, he needs to get that treatment and whatever other assistance he can receive in an environment where he can't hurt anyone else. Because that's the one thing that we do know. Any relapse is going to result in someone being hurt. For now, he has victims. At some point in the future, he may become one, but we just know that over and over we've seen this play out in many, many instances. The state will second defense counsel's recommendation, and the court has that recommendation, and we believe that it is a good outcome that will not only allow Mr. Heaton to acknowledge and take responsibility, but will keep society safe, so that people like Ms. Avery, who's in the courtroom today, don't have to live in fear, don't have to wake up screaming in the middle of the night, that they can know that at least for the foreseeable future, these things won't happen again. Relative to restitution, the state filed a motion for restitution for $6,051.48. I'm fine with setting that for hearing. I believe that in the interim, counsel and I can go through the motion for restitution and likely have that resolved prior to a setting for that hearing.
All right.
Thank you, Your Honor.
Thank you, Mr. Harris. Mr. Heaton, you have an opportunity to make a statement directly to me, but you don't have to say anything at all. There's no negative meaning or inference I ever place on a defendant who chooses to stay silent at this stage of the process, because you do have the right to stay silent. But if you want to make a statement, now's your chance. Is there anything you want to say?
Yeah.
Go ahead.
I want to tell Charlie I'm sorry, first off.
Okay.
I know don't make it right, but I'm sorry. And also about the treatment stuff, give it to me. I'll do it. Nobody's ever offered it to me. So whoever keeps saying they gave me treatment's wrong. I've tried to get the treatments many times. I just keep getting thrown in prison, so if that's treatment, that's, you guys gave it to me, that's for sure. But it's hard to get treatment when you're working all the time. When I get out, I work constantly. So if you want me treatment, give it to me, I'll do it 100%. That's all I got.
All right. Mr. Heaton, are you satisfied with Mr. Gustavus's representation?
Yes, sir.
Mr. Gustavus, any legal reason I should not impose sentence today?
No, Your Honor, there's not.
All right, Mr. Heaton, based on your previous pleas of guilty, it is the judgment of the court that you are guilty of the following: battery, domestic violence with traumatic injury under Idaho Code 18918 subsection 2, possession of a controlled substance, and evidence destruction or alteration. In getting ready for today, I looked at the entirety of your file. That includes the pre-sentence investigation report that everybody's been talking about. But it also includes the initial police reports and affidavit of probable cause that started this whole thing. I have to keep in mind the objectives of sentencing that have been outlined by the Idaho Supreme Court. Those objectives include punishment, rehabilitation, protection of society, and deterrence for you and others. I also have to look at Idaho Code Section 19-2521. That's a code section that outlines reasons why a court would or would not place someone on probation. With all those factors in mind, and after having reviewed the plea agreement, I do want to make some comments, but I'm advising the parties that I will be bound by the plea agreement as presented to the court. But I needed to make sure that I felt comfortable with that. So I do want to make some statements, some of which have been noted by your attorney or the state's attorney or even just yourself. You're 55 years of age, you have an LSI score that's 33, which is high. The importance of that number, and that was in 2019. But the importance of that number, Mr. Heaton, is there's a statistical correlation between that number and whether somebody in a similar circumstance as you would commit a crime in the future. And so the higher that number goes, statistically, there's a greater likelihood that you could commit a crime in the future. That's the bad news. Good news is if you work hard and you work on the factors that go into that number, you can actually work that number down. But that's going to include working on some of these things. You do have a significant criminal history going back to when you were a juvenile. You do have other assault or battery convictions. The significant severity of the events that were outlined in the initial records leading to these charges, an indication that you weren't taking your medication as prescribed, and you're probably self-medicating on a controlled substance, which is a bad combination. You do have some employable skills. You do have your high school equivalency. You are accepting responsibility for these actions. Just given the history, Mr. Heaton, I think the sentence is appropriate as recommended through the plea agreement.
Yes, sir.
So it is a judgment of this court that for the crime of battery, domestic violence with traumatic injury, you'll be sentenced to a 5-year determinate period of time followed by a 5-year indeterminate period of time. For possession of a controlled substance, you'll be sentenced to a 5-year determinate period of time followed by a 2-year indeterminate period of time. And for the evidence destruction charge, you'll be sentenced to a 5-year determinate followed by a 0 indeterminate period of time. Those sentences will be imposed. They will all run concurrent to each other. They will also run concurrent to cases CR 2012-12074 and CR 2022-183067. We'll have fines imposed in these matters. The fine for the battery with domestic violence will be $2,000. Fine for the possession of a controlled substance will be $1,500. The fine for the evidence destruction will be $1,000. We'll pay court costs. For the battery charge, there's a civil penalty under Idaho Code 1953-07. We're going to impose a civil penalty in the amount of $3,000. Restitution will be held open. We will schedule a hearing for that restitution. which time the state will have to make proof to me that the restitution is involved unless the parties advise otherwise. I'm imposing this sentence just based on the significance of the crime, significance of your criminal history. Anything other than imprisonment would not be appropriate, and my hope is that this is an appropriate deterrence. While you're incarcerated, I'm also going to order that you be evaluated for your mental health issues, get an update evaluation, and that you follow through with treatment as required. My hope is that the IDOC provides you with treatment while you're incarcerated so that you can learn how to handle your anger issues, you can learn how to handle any other mental health issues that you suffer, so that at some time IDOC feels comfortable placing you back in society, and society feels comfortable, and you feel comfortable with yourself. You spent a lifetime sitting in that chair, Mr. Heaton. You know it, I know it, and I know you'd rather not. You gotta figure out how to curb your impulses and control them, and figure out a better outlet if you start to feel this way in the future. Again, my hope is IDOC gives you appropriate treatment to help you learn how to handle these issues. Mr. Heaton, do you understand the sentence I've imposed today?
Yes, sir.
Mr. Gustavus, anything I need to correct or clarify?
No, Your Honor.
Mr. Harris?
No, Your Honor.
And that will be the order of the court.
Did you get a fee for public defender
I did not get the fee for public defender, $500 for public defender.
for the total case?
And I would also note, Your Honor, I didn't ask it, but would love to have the NCO extended at least as long as the term.
I don't know the term of the NCO right now, but I will extend it for the 10-year period, Mr. Heaton. We'll advise you that before that 10-year term expires, the victim in this case does have the right to ask for an additional extension. If that happens, you will be given notice of that. But at this point, it will, no contact order less 10 years.
Thank you.
And with that, Mr. Heaton, do you have any questions about that sentence?
No, sir.
Okay. Need to advise at this stage of the process, Mr. Heaton, you have appellate rights that attach to your case. You can't appeal my decision, but you have to do that within 42 days. If you think my decision is illegal or too harsh, you can seek relief under Idaho Criminal Rule 35, but you need to do so within 120 days. Finally, you can always try and seek relief under the Idaho Uniform Post-Conviction Relief Act. You have 1 year after your appellate rights expire to do so. You have a right to have an attorney assist with all of those appeals, and if you cannot afford one, one will be appointed for you. Do you understand your appellate rights?
Yes, sir.
All right. And with that, Mr. Heaton, I will remand you back to the Bonneville County Sheriff. He will eventually turn you over to the Idaho Department of Corrections to serve that sentence. We are in recess. You are excused.